Okay, I have some questions about my turning myself into the sheriff department.
Okay, what specific questions do you have about turning yourself into the sheriff's department? Let's go through them one by one.
Yesterday, I turned myself in to a sheriff's department in White County, Indiana.
Got it. How did it go? And is there anything specific you'd like to discuss or need help with following that?
I have an arrest warrant out of Louisiana for a misdemeanor resisting an officer failure to ID charge, and I turned myself into the sheriff's office in Indiana.
Got it. Since you turned yourself in regarding a warrant from Louisiana, what would you like to know about the next steps? Are you concerned about the extradition process or anything else?
The sheriff called the sheriff called the prosecutor in Louisiana.
Okay, did the sheriff or prosecutor give you any information about what to expect next, such as the extradition process or any steps you need to take?
The prosecutor, Billy Joe Harrington, did not call back.
All right. Without a response from the prosecutor, it's a bit unclear what the next steps will be. Typically, they would inform you about extradition proceedings or any other legal processes that will follow. It might be a waiting game for now, unless you hear back from them. Is there anything specific you'd like to prepare for while you wait?
The sheriff said that I am on the NCIC. Do you know what the NCIC is?
Yes, the NCIC stands for the National Crime Information Center. It's a computerized database used by law enforcement agencies across the United States. Being on the NCIC means there's an active warrant for your arrest that's accessible to law enforcement nationwide. It alerts other agencies that you have an outstanding warrant from Louisiana. Did they mention what might happen next, given this information?
No, they did not.
Since the sheriff didn't provide details on what happens next, it might be wise to prepare for the possibility of extradition. This could involve being transferred back to Louisiana to face the charges there. It could be helpful to consult with a lawyer who has experience in interstate legal issues to guide you through this. You're welcome. If you have any more questions or need further assistance, feel free to ask.
Does the NCIC mean that we are supposed to get arrested? Is the NCIC there to have people arrested?
Yes, the NCIC is a tool used by law enforcement agencies to share information on individuals with outstanding warrants, among other things. When someone's information is entered into the NCIC, it alerts law enforcement across the country that this person has an active warrant. It essentially indicates that law enforcement should arrest the person if encountered to address the outstanding warrant.
Are there any situations where if the person is on the NCIC that they should not be arrested?
Typically, an entry in the NCIC indicates that law enforcement should arrest the individual. However, there can be exceptions or special circumstances. For instance, if the warrant has specific conditions attached, like extradition within certain states only, or if there's a clerical error in the entry. Additionally, if the person has valid legal documentation showing the warrant is resolved or not applicable, they might avoid arrest. But these situations are quite rare, and law enforcement usually acts on NCIC entries by making an arrest.
Is the NCIC supposed to have information on whether the arrest is extraditable or not?
Yes, the NCIC entry typically includes information on the extradition limits of a warrant. This means it will indicate whether the warrant is extraditable, and if so, it might specify any geographical limitations, like only within certain states or regions. This helps law enforcement determine how to proceed if they encounter the individual.
What if the NCIC does not have any information about whether the arrest warrant is extraditable or not?
If the NCIC entry doesn't include extradition information, law enforcement might need to contact the agency that issued the warrant for clarification. This is because extradition policies can vary significantly depending on the state and the severity of the offense. If there's no clear indication, officers may proceed with caution or seek guidance from their superiors or legal counsel before making an arrest or initiating extradition.
What if the people who put out the arrest warrant
If the agency that issued the arrest warrant didn't provide specific extradition details in the NCIC entry, it could lead to uncertainty for law enforcement officers. In such cases, officers would typically reach out to the issuing agency to clarify whether the warrant is extraditable and under what conditions. This ensures they proceed correctly according to the warrant's intent and legal requirements.
Okay, the NCIC, what's that?
Sorry about that. Were you asking for more information about the NCIC or something else? Let me know how I can help.
Yeah, I don't really have any other questions that I could think of.
No problem. If anything comes to mind later, feel free to ask. Take care.
Because I have a bench warrant, and
Okay.
I have a
A
bench warrant, and it doesn't explain anything about extradition. And I turn myself. If I turn myself.
No worries.
If I turn myself in to sheriff's department, and they turn me away.
If the sheriff's department turns you away, it could be due to a lack of clear extradition information or other jurisdictional reasons. In such cases, it's best to consult with a lawyer who can provide guidance on how to proceed, especially given the complications of an out-of-state warrant. It sounds like this situation is a bit complex. How can I assist you further with this?
The officer is commanded to arrest the body of me, but there's no clear explanation.
If there's no clear explanation in the warrant or NCIC entry about extradition, it can create uncertainty. In this situation, consulting with a lawyer who has experience with extradition cases could be very beneficial. They can help clarify your legal position and advise on the best course of action.
Well, so far, I've turned myself in to one sheriff's department to find out that I'm on the NCIC. I showed the sheriff department my bench warrant, and it is unclear because only the prosecutor did not contact the sheriff department and explain whether it's extraditable or not.
It sounds like the uncertainty lies with the prosecutor's office not clarifying the extradition terms of your warrant. Given this, consulting a lawyer familiar with extradition laws would be a wise step. They can communicate with the prosecutor's office on your behalf, seeking clarification on the warrant's terms, and advising you on how to proceed. It's important to have legal guidance to navigate these complexities.
What is the standard that the prosecutor must follow when it comes to bench warrants? What standards are they held to?
In general, a prosecutor is expected to ensure that the information accompanying a bench warrant, including extradition details, is clear and accurate in the National Crime Information Center section. Prosecutors have a duty to uphold the law, act in the interest of justice, and provide sufficient information to law enforcement to execute warrants lawfully. For extradition, it's crucial that they clarify whether the warrant is extraditable and under what conditions. If they fail to provide necessary details, it can lead to complications or delays in enforcing the warrant. If you believe there's been an oversight or ambiguity, a legal professional can help in communicating with the prosecutor's office for clarification.
If the prosecutor is not clarifying, then they're not doing their job properly.
It can certainly be frustrating when there's a lack of clarity or communication from the prosecutor's office, especially when it concerns serious matters like warrants and extradition. Prosecutors have a duty to provide necessary information to law enforcement and ensure that justice is served effectively. If you feel this duty isn't being met, a lawyer can help advocate on your behalf to get the clarity and action needed.
Is something, if the prosecutor does not explain their warrants clearly enough, can you complain about them to the lawyer bar?
Yes, you can file a complaint with the State Bar Association or the appropriate disciplinary board if you believe a prosecutor has acted unethically or failed to fulfill their professional responsibilities. However, bar complaints typically address serious ethical violations or misconduct. If the issue is primarily about lack of clarity or communication, it may be more effective to address it through legal channels, such as your attorney communicating directly with the prosecutor's office for clarification, or escalating the matter to a supervising authority within the prosecutor's office. It's essential to gather all relevant documentation and, if possible, seek legal advice before filing a complaint to ensure your concerns are appropriately addressed.
It sounds like you're trying to protect the prosecutor.
I'm not trying to protect the prosecutor, just providing information on the usual process. It's essential for everyone in the legal system, including prosecutors, to act ethically and transparently. If you believe a prosecutor isn't fulfilling their responsibilities, it's within your rights to seek clarity and accountability. Would you like more information on how to proceed with a complaint or any other aspect of your situation?
I have heard about people who spent 30 days in jail waiting on a prosecutor's response. Does that sound justified?
Situations where individuals spend extended periods in jail waiting for a prosecutor's action or a court hearing can happen, especially in cases involving extradition or when there are delays in communication between jurisdictions. While not necessarily justified, these situations often arise from procedural complexities, bureaucratic inefficiencies, or legal safeguards that can delay processes. It's a challenging situation, and such delays can be stressful and frustrating for those affected. If someone finds themselves in this position, legal representation can be crucial in advocating for timely action and protecting their rights.
I know it's not easy to prove a prosecutor intentionally delays their response, but they can delay response in an unethical way, and there has to be ways to remedy that, right?
Absolutely. Intentional delays by a prosecutor can be unethical and harmful. Proving intentional delay can be challenging, but there are ways to address it. Legal representation. A lawyer can file motions to compel action or expedite proceedings, putting pressure on the prosecutor to act. Judicial intervention. A judge can be asked to intervene if there are unreasonable delays, potentially leading to sanctions or orders to act. Filing a complaint. If there's evidence of unethical behavior, a complaint can be filed with the state bar or disciplinary board. 4. Public pressure. In some cases, public attention or media coverage can prompt action by highlighting the issue. Each situation is unique, so it's important to seek legal advice to determine the best course of action.
Okay, thank you.